Good morning. Thank you all for being here today. My name is Kate Judson. I'm the Executive Director of the Center for Integrity in Forensic Sciences. Our center works to end the use of unreliable forensic theories that far too often are used to charge and convict people of crimes that never actually occurred. Robert Roberson's case is one of the most egregious examples of this problem. I'm also joined today by Josh Burns, Audrey Edmunds, Anna Vasquez, and Sabrina Butler-Smith, whose personal stories you will hear shortly. The shaken baby syndrome abusive head trauma hypothesis that was used against Mr. Roberson is not science, plain and simple. Our office consults on hundreds of cases each year, many of which involve people who were wrongfully convicted using this now discredited hypothesis, and his case represents one of the most extreme examples. At trial, Mr. Roberson's defense lawyer did not even try to challenge the state's theory. While we know far less about knew far less about SBSHT at the time of Mr. Roberson's trial, there were still opportunities for lawyers to challenge this evidence. But now, no one who is well informed about these issues would give the kind of testimony leveled against Mr. Roberson at his trial. Experts would no longer claim that only shaking can cause the kinds of findings that Nikki had. They could not responsibly tell a jury that Nikki was a healthy child. They could not credibly assert that only abuse and not accident or illness could cause Nikki's condition. And that's because in the 2 decades that have passed since Mr. Roberson's trial, evidence-based science has roundly debunked the version of the shaken baby syndrome hypothesis that was put before his jury. The National Registry of Exonerations lists many individuals who've been wrongfully convicted and later exonerated of charges involving SBS-AHT. And this does not count people who have been acquitted, people who are awaiting trial, and people like Robert awaiting post-conviction relief. In fact, the Center for Integrity in Forensic Sciences has represented clients in very similar cases who are free today because of this change in scientific understanding, while, tragically, Mr. Roberson continues to face the looming threat of execution. In 2002 and 2003, when Mr. Roberson was accused of committing a crime based on a shaken baby diagnosis and then convicted and sentenced to death, the hypothesis was considered established medical wisdom, even though it had never been validated with reliable scientific testing. And when he was tried, medical doctors were being taught that child abuse could be presumed whenever one or more internal head conditions was present, even when the child had been exhibiting serious medical problems. Doctors in that time period were not aware that other phenomena, such as falls with head impact or naturally occurring diseases like pneumonia, could cause the same constellation of internal conditions that Nikki had. Evidence-based medicine has shown now that the triad of internal head conditions observed in Nikki is even proponents of the current version of the shaken baby hypothesis, what is now known as abusive head trauma, would never suggest that abuse can be diagnosed without a differential diagnosis that first excludes all other possible causes of the conditions that are displayed. Mr. Roberson did not receive the benefit of the medical analysis required today. And today, we know that all of Nikki's symptoms can be explained by severe undiagnosed pneumonia, improper medications that were prescribed by her doctors, and an accidental fall likely precipitated by her struggle to breathe during the night. Robert's case is not about whether shaking can cause injury or whether violent shaking is abusive. There's no question that both are true. This case is about whether doctors can reliably find abuse when a child has a collection of medical findings that are consistent with a variety of causes and in the presence of a separate natural disease process. Here, they committed a grave error that has the very real potential to end a man's life. Nikki's death was a tragedy, but there is no evidence that her father abused her. He committed no crime, and yet he faces the looming threat of execution. We urge the courts to intervene. And while our focus is on the courts, given Mr. Roberson's pending appeals, we encourage anyone with the power to stop his execution to do so. Science proves Robert Roberson did not harm his daughter and that she died because of readily identifiable natural and accidental causes. The Texas courts and the Texas authorities have all of this evidence before them. They must not ignore it and allow an innocent man to be executed. Now, Josh Burns, an exonerated father personally impacted by a wrongful conviction and wrongful incarceration, will read a letter signed by a group of parents and caregivers who were wrongfully convicted and have been exonerated. Mr. Burns, an airline pilot, was wrongfully convicted of shaking his infant daughter and spent 10 years fighting to obtain official recognition of his innocence. You should also know that the exonerees letter will be made available to attendees after the event.
Thank you. I want to thank everyone for being here today, and I am privileged to read this letter that has been signed by 20 exonerees. An open letter to the authorities in Texas. Robert Roberson stands alone as the only person facing imminent execution at the hands of the government for a conviction based on the discredited shaken baby syndrome hypothesis. But he is not alone in being wrongfully charged and convicted of harming a child. We, the signatories below, face the same nightmare. We all know the horror of being wrongfully accused and convicted of having hurt a beloved child. Some of us sought medical help for having hurt a beloved child. Some of us sought medical help for a sick and injured child only to be blindsided by abuse accusations stemming from hasty, scientifically dubious diagnoses, including shaken baby syndrome. In the cruelest cases, while grieving the loss of a child, we were unjustly charged with murder, convicted, and sentenced despite considerable reasons to doubt the allegations and despite medical alternatives for the child's condition. This is what happened to Robert after he brought his seriously ill daughter, Nikki, to the emergency room. Thankfully, we all secured relief from the criminal legal system after years of heartache, anguish, and despair. We have been reunited with our families and communities, free to rebuild our lives stolen from us by the state. This is what we want for Robert and what he deserves. While many of us were acquitted or exonerated after evidence-based medicine prevailed in court cases, Robert has not benefited from the significant advances in science since his trial more than 20 years ago. Although the shaken baby syndrome hypothesis has been challenged or outright debunked by numerous medical and judicial communities, Robert once again faces execution. How is this possible? His case is an extreme example of the harm that can be caused by medical misdiagnoses of child abuse, resulting from a rush of judgment in the face of tragic and complex medical crises. This is a terrible impasse. Robert's life hangs in the balance. He is scheduled to be executed and put to death by the state of Texas on October 16th, 2025. There is no way to reverse a wrongful execution, but it can be prevented. We implore you to prevent the wrongful execution of this innocent father. Thank you.
Thank you very much. We'll now hear from Audrey Edmunds, who was a happily married young mother of 2 with a baby on the way, and the neighborhood soccer mom in a small Wisconsin town when a child tragically died in her care. Like Mr. Roberson and Mr. Burns, she was wrongfully convicted using the SBS hypothesis and spent 13 years in prison before science finally proved her innocence and she was released. Ms. Edmunds' case is the first published appellate decision in which judges found that the change in science around shaken baby syndrome merited a new trial. Ms. Edmunds will not be on video because of technical challenges that we're experiencing this morning, but you will all be able to hear her. Audrey, you can go ahead and unmute yourself when you're ready. Thank you.
Good morning. I'm Audrey Edmunds, and I thank you all for listening, for caring. In October of 1995, I had a young 7-month-old in my care. She was fussy. She would not take her bottle. She had had several other incidences with her parents over the last 7 months. They had taken her 25 times in 27 weeks to the doctor due to her excessive crying and medical circumstances. The doctors never checked any kind of CT scan or MRI. They did not look at her background. And on the morning of a Monday in 1995, she went in distress in my care after being with me for only an hour. She had projectile vomited before coming to my house. Later, about 7 months later, I was accused of shaken baby on junk science from 20 some years ago that had no scientific or medical evidence to prove it. I went to trial in November of 1996. I was found guilty, and in 1997, I was sentenced to 18 years in prison. With the work of many new medical doctors, the coroner, other medical experts, they've noticed that there was a location of the subdural that was never assessed because it was not in a place that could have caused what the doctor's trial said. There are over 33 symptoms that mimic child abuse, and all of these should be definitely looked at as they are scientifically and medically proven. All of these need to be considered because the junk science of shaken baby syndrome, even Dr. Gutkelch, who originated this, came forward many years ago and said it's all junk science. So please help stop Robert Robertson's execution. There were flaws, it's proven. There are many things that need to be looked at, the neck, the external bruising. Is there anything? What else caused these symptoms? Thankfully, after days short of 11 years, I was released after many experts had gone through and attorneys had gone through the appellate court. The wonderful Wisconsin Innocence Project took on my case, and I was released in 08 of February, and that July the case was dismissed and I was exonerated. So I hope and trust that these voices will be heard to stop Robert Robertson's execution, and it will continue to help others to not have to go through the nightmare that many of us have gone through with the inconclusive, incorrect diagnosis of SBS or head trauma. Thank you.
Thank you very much. Let's go now to Anna Vasquez, who is the Director of Education and Outreach at the Innocence Project of Texas and a member of the Executive Board of the Innocence Network. She was wrongfully convicted in part based on flawed scientific evidence of child abuse that never occurred. She spent 13 years in prison and was finally exonerated in 2016.
So thank you for that. And I want to thank everybody for being here and bringing awareness to this case. And I also want to thank the exonerees for speaking out, because I do know how difficult it is to relive that trauma. So thank you for that. I have been following Robert's case for a few years now. I've spoken out on behalf of him at the Capitol. I was there in Palestine when he was, when the date of execution was given. It was handed down. And I turned to look at him because he was in the courtroom, and I think I was more devastated, and I think he was in shock that this continues to happen. And the difference between myself and the others is that I wasn't convicted of shaken baby syndrome, but I was sentenced along with my 3 friends to a Texas prison behind child abuse. And it led to faulty science, which years later was proven that, and ultimately led to our exoneration. Many people have spoken out, many experts have spoken out on behalf of Robert and the science, and it continuing to change. And I think that we have to take that into consideration, that science is constantly changing, it's constantly evolving. And yes, it may not have been a thing back then, but it is today. And so many people have talked about it and spoken out. And I will continue to be there for Robert, even though I've never met the man. But I do know how it feels to be wrongfully convicted, asking for help, looking for the light at the end of the tunnel, and it's not there. The difference between myself and Robert is that this could be fatally wrong. So I'm asking the people of Texas to please look at everything concerning Robert's case. Please take that in consideration. This man does not deserve to die. It was a horrible accident. It was a horrible medical condition. And we need to remember that. Thank you.
Thank you very much. Now we'll turn to Sabrina Butler-Smith, who was a loving teenage mother when she was wrongfully convicted in Mississippi of causing the death of her 9-month-old son. She spent more than 6 years in prison, including 2 on death row, before becoming the first woman to be exonerated from death row in the United States. Ms. Butler-Smith is the communications specialist at Witness to Innocence, an organization of, by, and for death row exonerees.
Hello, thank you all very much for being here today. And I am really just overwhelmed at the situation with Robert Roberson, because I too sat on death row and was begging for my life. And to be accused of killing your own child is one of the hardest things that you could ever fathom. I mean, for him to be sitting there waiting for an execution. My execution was July the 2nd of 1990, and I did not have anyone to talk to or to tell me, that this was actually not going to happen. I had to go back to court. And being 17 years old at the time, it was devastating. And to know that this country is continuing to take the lives of its citizens and not looking into the facts of the case. Shaken baby syndrome is junk. You have to know for sure before you make these type of decisions. You can't just go around killing people. We're not God. You kill somebody, you can't fix that situation. I almost lost my life. And I'm here today not because of the system, but in spite of it. I had an attorney, Clive Stafford Smith, who came in, him and Rob McDuff, and they proved my case. My case was never a murder. It was never a murder. My son had heart, kidney, and lung problems, and it had nothing to do with me at all. Today, I have a child that's 22 years old that has the same disease. She is a girl. And for you to say, okay, Robert, we're going to kill you in October. It makes no sense. It makes no sense. How do you call that justice when you know there's issues and flaws in his case? Please, please don't do this. Don't do this. It's not right. You're making a mistake. Thank you.
Thank you very much. Finally, we'll hear from Keith Finley, Professor Emeritus from the University of Wisconsin Law School, co-founder of the Center for Integrity and Forensic Sciences, and an attorney who's really been a pathbreaker on forensic science issues, including, perhaps especially, wrongful convictions in shaken baby syndrome, abusive head trauma cases.
Thank you, Kate. First, I want to thank all of these brave exonerees for sharing their stories with us, all extremely traumatizing stories for them to relive. And I want to apologize to them on behalf of our medical and legal systems for failing them so egregiously. These exonerees represent just a few of many innocent, loving parents and caregivers who've been exonerated in SBS AHT cases after courts have considered all of the new, shifting scientific evidence that courts in Robert's case have inexplicably refused to consider. Robert is therefore not alone in having been wrongly convicted, but he is alone in one respect. He's the only person in the United States, and to my knowledge, the world, who will have been put to death based on this unvalidated and discredited scientific hypothesis if his death sentence is carried out. If we as a community value life and a just criminal system at all, this execution cannot proceed. All available evidence now shows that Robert's daughter's death was not a crime. She died of natural causes, including virulent advanced pneumonia that her doctors missed, and then overprescribed dangerous respiration suppressing drugs. Her condition was perhaps exacerbated then by a fall from bed in her sleep during the hours before her father woke up to find her unresponsive and blue from oxygen deprivation. There simply is no evidence of a crime, but plenty of evidence now of a tragic but natural death. The child abuse physicians at the time this case was prosecuted did not review Nikki's medical history that revealed her raging pneumonia and ongoing serious illness marked by breathing difficulties. Unaware of those facts, they instead looked at her brain findings and simply presumed abuse. We now know better. Texas should not be afraid to admit when a mistake has been made in order to prevent a wrongful execution. So why do we say the SBS-AHT hypothesis has been discredited? Well, first, because it began as an untested hypothesis, and because there was no ethical way to test it, researchers relied on mere assumptions and beliefs. Many studies just started with the assumptions that a certain set of intracranial conditions proved that shaking had occurred, and then the belief that those studies had identified cases of abuse kept being treated as proof of the hypothesis. The result was circular reasoning and a self-fulfilling prophecy. It's also untested and discredited because we now know what doctors at the time of trial did not know, that many natural and accidental conditions can cause all of the internal head conditions that at the time the doctors almost universally believed could only be caused by violent shaking, perhaps accompanied by an impact. That includes subdural hematomas, retinal hemorrhages, brain swelling or brain dysfunction, the traditional triad that physicians used to rely on to diagnose SBS-AHT. And the alternative conditions that we now know about include the kinds of infections and accidental fall that Nikki experienced here. It's also untested and discredited because we now know from consistent biomechanical research that the most violent shaking an adult human being can muster comes nowhere close to producing sufficient forces in an infant to cause the kinds of internal head conditions Nikki exhibited, and even far less forces in a toddler like Nikki. Science now tells us that shaking is indeed a highly improbable cause of these kinds of symptoms. That is, shaking has never been proven to cause any component of the SBS triad, the conditions observed in Robert's daughter, Nikki, that led to a supposed diagnosis of SBS. Given all of this, even the originator of the SBS hypothesis, Dr. Norman Guthkelch, who first proposed the hypothesis in 1971, revisited his hypothesis late in life, a little more than 10 years ago, and warned that it was and remains pure hypothesis, not proven science, and that it accordingly should never be the basis for prosecuting anyone. He would have been horrified had he lived long enough to see that the government intends to rely on his hypothesis, his thought experiment, as the basis for executing someone. But even if one accepts the hypothesis in general, this case doesn't pass muster under current medical standards. Current standards, as endorsed by groups like the American Academy of Pediatrics and the Society for Pediatric Radiology, now recognize that neither the triad nor any other particular findings can be relied upon solely to determine a child has been abused, and that all of the relevant findings have multiple non-abusive etiologies. They now demand that physicians undertake a full differential diagnosis in every case, that is, consideration of all plausible alternative causes, and they allow an abuse determination only if all of the plausible alternatives have been ruled out. Those plausible, indeed in this case almost certain, alternatives were never even considered at the time of Robert Roberson's trial. Today, Robert Roberson would never be subjected to the kinds of uncontested testimony that condemned him here. He almost certainly could not be convicted under modern medical and scientific standards. This death sentence cannot go forward. Thank you.
Thank you very much. Now I will be happy to field questions for the panel. If you have questions, you may post them in the Q&A, and we'll respond from there. Please be sure that you're putting questions in the Q&A versus the chat, because we won't be able to monitor the chat. So Q&A, please. And when you are asking a question, please include your name and the name of the outlet for which you work. Okay, I do see one. From Kimberly Reeves, whose outlet I don't have. Again, please share that when you ask a question. She asks, how do other states deal with medical updates? How legally can you trigger reconsideration of a case if the interpretation of forensic science changes? I'm gonna give that question to Keith since it is your field of expertise.
Sure. Virtually every state in the country has a process for considering newly discovered evidence, and it is widely being accepted throughout the country that when a prosecution depends heavily on scientific evidence and the nature of the science changes, that can indeed constitute the kind of newly discovered evidence that can be used to reopen a conviction. Audrey Edmunds' case, who Audrey we heard from earlier today, was the first person in this country that we know of whose conviction was overturned based on that kind of newly discovered evidence procedure, where the court concluded that the consensus, the former consensus around shaken baby syndrome had unraveled, and that because the jury had been told that it was settled indisputable science at the time, but we now know that every component of the hypothesis is either wrong or subject to serious dispute, that a jury should consider that at a new trial. Texas, I hate to use the word ironically because that sounds light, but it is true that Texas is one of the states that has gone even a step further and has a particular writ procedure for reopening cases when new science emerges. It's sometimes called the junk science writ law. And it is absolutely inexplicable why the Texas courts have not employed that statute to grant Audrey Edmunds, Robert Roberson relief in this case. And indeed, a bipartisan group of legislators in the Texas legislature have recognized that flaw and have of course expressed serious concerns that the courts have not implemented that statute as it was meant to be implemented to grant relief in cases like this. And I just want to emphasize one final thing, and that is one reason why the shifting science is so important in a case like this is because these cases, these shaken baby syndrome or abusive head trauma cases, are virtually unique in the law, in that the science, that is the medical or scientific opinions of experts, comprise the entirety of the prosecution in many such cases. They did in Robert Roberson's case. No one saw him do anything to harm this child. He didn't confess to anything. It was all medical opinion. There's no other kind of case I know of where medical opinion forms the evidentiary basis for the entire case. What that means is that the science takes on outsized importance in cases like this. And so when the science shifts, as it has over the last 20 years, courts have to take it upon themselves to recognize that the science has shifted, that the basis, therefore, for the conviction is no longer firm, and that a reexamination and a new trial at worst is absolutely essential.
Thanks, Keith. This one is quick. David Martin Davies from Texas Public Radio asks, has the American Academy of Pediatrics come forward with a statement on Robert Roberson's case? To my knowledge, no, they have not. The next one is Juan Lozano with the Associated Press. Are there similarities between Mr. Roberson's case and the cases of Mr. Burns and Ms. Edmonds in terms of what authorities focused on or what evidence they relied on? And could there be something in the exonerations of Mr. Burns and Ms. Edmunds that could help Mr. Roberson's case. I will begin to answer this, and then I will pass because I think there are other folks on the panel who have helpful insight. So one of the things that stands out to me about Mr. Roberson's case versus Mr. Burns and Ms. Edmunds' cases is that in Robert's case, there's a fairly clear causation explanation. Often in SBS-AHT cases, what lawyers can say is that what the doctors are claiming happened, there's not enough evidence of it, and that testimony maybe given at trial was wrong. But we might not always know exactly what did happen. What's interesting and different about Mr. Roberson's case, which in my mind makes it, especially compelling, is that there is so much evidence in his case of an infection that was extremely serious that led to problems with clotting and bleeding. For example, Nikki had pneumonia. On one of the days before she went to the hospital, she had a 104-degree fever. There were other, perhaps even clearer explanations in that case. Keith, is there anything you'd like to add to that answer?
Yeah, I agree with what you said. I will amplify. I know Audrey's case very, very well because I was Audrey's post-conviction lawyer, litigated that case. And I can tell you that the nature of the evidence used to convict in both cases was extremely similar. It was the same kind of stuff. It was the subdural hematoma, retinal hemorrhages, brain swelling, that kind of thing. But I agree with you in that as strong as Audrey's case was, and as clearly innocent as she is and was, in some ways Robert's claim of innocence is even stronger. In both cases, the child who died showed signs of prior illness. In Audrey's case, the child had a chronic subdural hematoma, meaning a previous brain bleed that could have rebled. The child was also exhibiting signs of illness, and as Audrey related, had been to the doctor numerous times. But in Robert's case, the child was even more acutely ill at the time prior to collapse. And we now know that she suffered from serious, virulent double pneumonia and from overprescription of respiratory suppressing drugs that are not prescribed to children anymore, precisely because they are dangerous and can cause death. We know that she fell out of bed, possibly as a result of that. All of these things are clear indicators of what actually happened in this case. And so among the SBS cases that I've seen, this is one of the clearest ones in which we know what happened and we know it wasn't a crime.
Thank you. The next question is from Kimberly Reeves from Barbed Wire. She asks, my understanding is that the state's response is that there is still enough proof of abuse to convict Mr. Roberson. Is that your understanding? I think that is the state's response, but in their papers, there has not been a meaningful effort to engage in this new science. So claiming that there's still enough proof of abuse without addressing the causes of the wrongful conviction, it's not responsive to the question the courts are being asked. So that's yes, I think that's what they're saying, but I don't think it's correct, and they've really missed an opportunity to address the real causes of wrongful conviction here. One thing I did miss on the previous question is that Josh's case, Mr. Burns's case, happened much later than Robert's. His accusation was many years later. So in many respects, his case differs because of the really significant change in science that occurred between 2002 when Robert was tried and 2014 or 15 when Josh was tried. Josh, is there anything you'd like to add to that?
Well, I think one of the things that I can speak to with Robert's case and mine. First of all, let me start by saying I've read the entire trial transcripts of Robert's case, and what the state asserts now is pretty much stuff that's been disputed and discredited on the witness stand in court, and they're holding on to things that are outright lies. That's just the Attorney General of Texas is stating things that have been completely discredited in the court of law. I just don't understand how that can happen. In my case, yeah, it was Naomi was in the hospital for 10 days. They suspected a virus, and then they did a bedside retinal exam, found retinal hemorrhaging. She had a very traumatic birth. So once they found the retinal hemorrhaging, everything changed. So there was just no other explanation. The child abuse pediatrician became involved, and that's just where you become a cog in a wheel, and it's kind of unstoppable. So
Thanks, Josh. Another question from David Martin Davies of Texas Public Radio. If Robert Roberson was granted a new trial, which is being sought, do you think that he would be found not guilty? I can answer that. While we never can tell or predict precisely what a jury would do, I think that the evidence is there to show that he is absolutely innocent of these charges. What's also extremely important, especially in the rules of our criminal legal system, is that the jury would hear a completely different case than they heard 20 years ago. They would hear about Nikki's illness. They would hear about the new science. The attorneys would be able to obtain and present expert witnesses who could explain some of these findings. So it would be an entirely different trial now than it was at the time.
I would just add that I think
yeah.
it highly unlikely that the state could prove guilt beyond a reasonable doubt.
Yeah. That's right. Okay, another question from Alexandra Chacon, a documentary filmmaker. Why do you think child abuse pediatricians or doctors working on these cases never take differential diagnoses into account? There are thousands of rare diseases, after all. I think that now they're supposed to be taking differential diagnoses into account. There's supposed to be a thorough differential diagnosis. Clearly, it does not happen in every case, and it definitely didn't happen here. I don't know why that is, but it is a problem that persists. If anyone wants to add additional information, I mean, I really can't speak to what's in someone's mind, but now it would be required to do a thorough differential diagnosis of Nikki's condition. And at the time, that was not the guidance that was being given to physicians.
Kate, I have something I'd like to add to that.
Yeah, great.
Child abuse pediatricians, unfortunately, many of them, like the one in my case, had a federal grant to diagnose abusive head trauma, which is the new word for shaken baby syndrome. So unfortunately, with a lot of these child abuse pediatricians, they're pre-wired and motivated to find nothing but abuse. It's unfortunate. This subspecialty has become very reckless and motivated by money and federal dollars.
I would simply say also that it is the current standard that they're required to do a complete differential diagnosis. I would say that is that when all too often, however, even today, the differential diagnosis that is done is inadequate. And that's for a wide variety of reasons. Josh may be right about some of the motivation. I suspect a more benign interpretation of it is that child abuse pediatricians are engaged in what is, at least at one level, a noble enterprise of trying to protect children from child abuse. And therefore, they are very protective of their professed ability to determine shaken baby syndrome or abusive head trauma, because if they fear that the flaws in their diagnosis are made clear, it will make it harder for them to do that job. They are not neutral observers, though. They are not neutral scientific investigators. If you look at their literature, the literature is replete with references to the fact that we are the voice for the harmed child. We need to be biased in favor of protecting the child. And by that, they mean taking the child away from potentially dangerous home situations. That is, finding abuse when in doubt. It is a mission-driven inquiry, and it's made all the more difficult by the fact that they will readily acknowledge that there are no gold standard diagnostic or definitional criteria for shaken baby syndrome or abusive head trauma. There's no definitive test. It's a very vague, mushy, I know it when I see it kind of thing. And when you are mission-driven, as they are, you're much more likely to see it than not, and to rule out alternatives or claim to rule out alternatives even when you really can't. I mean, take for example congenital genetic abnormalities that might cause all of this, which we know exist. We don't even know what they all are yet. We're continuing to discover more and more of them regularly. There's no way to rule them all out. So they wind up making what is in their sense a probabilistic determination without revealing that it's truly probabilistic, saying it's probably abuse, but it's a probabilistic determination that's not based on any real data. They have no data to tell them how often they're right or wrong because there's no one who has access to ground truth. So it's all a very vague, very mushy, subjective area that makes it highly vulnerable to cognitive biases, motivated reasoning, things like the availability heuristic or the familiarity heuristic, which are known heuristics in psychology, that lead one to see a particular diagnosis when it's the one they're used to looking for. All of these kinds of things are at play here that make it really hard to conduct a real differential diagnosis, to do it rigorously, and that I think all help explain why, although it is the standard, even today, it's not usually done very well. But as Kate said, they didn't even pretend to do it at Robert Roberson's trial.
The other thing
Yeah.
that I think is
Can I say
important.
something?
Oh, of course, Sabrina, because you experienced this as well.
I wanted to say that with them having the misdiagnosis and all of that, then you run the risk of killing innocent people, and in my son's case, they did not look at his kidneys, they didn't look at his heart, they didn't look at his bowels, they didn't do anything to know that my son had serious medical conditions, and that caused him to pass. And now no one has said, okay, oh, but my bad, I'm sorry I made this mistake. And I'm looking at my daughter and she has the same problem. It's hereditary in my family, and no one, how could you try to kill somebody with this going on? That it makes no sense. It just makes no sense to me. I mean, to know that the system will take people and not do a thorough investigation and then say, okay, you're the murderer. That's horrible. That is horrible to me.
It's really heartbreaking. And Sabrina, you bring up a really good additional point, which is that even without all of the cognitive errors and motivations that Keith and Josh talked about just now, medical error is extremely common in our healthcare system. It
Absolutely.
is one of the most common reasons why people suffer adverse effects, serious consequences, even death in our hospitals in our country. So we know what research tells us is that between 10 and 20% of diagnoses by all physicians sort of across the board are late, delayed, or just missed, right? Or misdiagnosed. And while we don't know what the error rate is in these types of cases and accusations of child abuse, there's good reason to believe that it's on the high end of that because of the nature of the diagnosis or the nature of the determination, like Keith talked about, no gold standard, limited standards at all. And given that, while we don't know what the error rate is of child abuse determination, we have good reason to believe that it is far too high to be predicating anyone's death sentence upon.
Putting it another way, if there is an error rate, which we know there is from research, a misdiagnosis rate of 10 to 20% across all disciplines throughout medicine, even in those disciplines where there are definitive diagnostic tests and gold standard diagnostic criteria, think about what it must be in a field like this, where there are no definitive tests and no gold standard diagnostic standards.
Exactly. I have another question from Juan Lozano with the Associated Press. What role do you think Mr. Roberson's at the time undiagnosed autism played in terms of authorities focusing on him as a suspect, and in terms of Mr. Roberson fully understanding what had happened to his daughter and being able to fully advocate for himself? I think that there's no question that it played a significant role. One of the things that can lead to medical and other types of professional error is bias, not malicious bias, but people's impressions of other human beings when they're talking to them. And you see that throughout Robert's case. There are multiple references to him having a flat affect, or him appearing flippant because of like a vocal tic that he has, or other assessments of his behavior that officials at the time believed made him appear more guilty, but we now know are related to his autism that at the time was undiagnosed. And there's no question that in the medical community and in the legal community as well, aspects about you personally if you're the patient affect doctors' decision making, and it in fact affects every aspect of your in interaction with the healthcare and the criminal legal system. I don't know if any of the folks on the panel who've experienced a wrongful conviction would like to add to that, or feel like they experienced that. That may have been part of the situation with you, Anna, if you feel comfortable talking about that.
Yeah, thank you. Actually, I do have a cousin that is on the spectrum, and just knowing about Robert's autism now, it completely makes sense on how things can be looked at under a different eye. And when I told you that I was there in Palestine when the sentence was handed down, I was so emotional. And when I looked at Robert, my opinion is that it could have been shock, but then it could have been his autism and just not realizing what just happened, or really, having a reaction to it. So, all that plays a part. And yes, it could have been taken completely different 20 years ago. Because like I said, I do have a personal experience. My cousin is on a spectrum, and I see him almost, every other week. So I understand how things can be looked at differently.
And
We don't have
you
to.
can correct me if I'm wrong, Anna, but in your case, my understanding is that you also experienced some prejudice that may have had a role in your conviction. Do you think that's fair to say?
Oh, absolutely. During in the early 90s, when myself and my 3 friends were accused of this, it was a time where being a part of the LGBTQ community was not acceptable. And I think that played a huge part. And as Josh and Keith had mentioned, having this way of looking at things, the pediatrician, the expert witness, was somebody that Bexar County used quite often dealing with child abuse cases. So that set standard of what they may see, I think it definitely played a part in it. And, also not to, throw this off or take it away from Robert, but my case also did involve the satanic panic that was circulating during that time as well.
Yeah,
Hey,
and
can I just add one thing to
absolutely.
that? In this case, we don't have to guess or speculate about whether the Robert's autism played a role in condemning him. We know it not only from the medical records that Kate referenced, that where where the medical providers were troubled by his lack of affect, but we also know it because Detective Brian Wharton, the lead detective on the case, has told us so now. Now that he has changed his mind and believes that Robert was wrongly convicted and is innocent, he tells us flat out that Robert's response was misread as a sign of guilt, not because they didn't realize that it was autism. We don't have to guess. We know it played a role.
Yep.
Anna referenced the satanic panic, and just for folks who may not be familiar with that rash of prosecutions, is another example of error by, again, people who were well-intentioned trying to protect children, but relied too much on junk science and other types of problems. I think we're probably pretty close to wrapping up. I see one last question from Kimberly Reeves, which is, why hasn't the junk science writ worked in the Roberson case? I don't think anyone has the answer to that. The lawmakers who made that law are certainly very concerned because they do not think it was properly applied. And they are really in a position to know. And I think that their difficulty with the way that the law that they wrote was applied is really instructive here. I don't know if there's anybody else who wants to add to that, but I think that's the answer to that question.
I want to say, before this wraps up,
Yeah.
to know that we support Robert, and we just want you guys to look at what's going on and let him go. Set him free, because this is wrong. We as exonerees have experienced so much time stolen. He has a lot that he has to endure once he comes out here, trying to figure out where he fits in at. And for this case to continue is just a farce. It's absolutely deplorable. So I ask you today, along with my exoneree brothers and sisters, set him free. Please set him free. Don't do this. It's wrong.
I don't think there's any better way to express the concerns that we and the exonerees all have about that. Sabrina, thank you very much. I could not have said it better. I really appreciate everyone being here today. The recording of this press conference will be available on the CIFS, the Center for Integrity in Forensic Sciences YouTube channel a little later today. It'll take some time for that to process properly. We'll send you the link to that. In the chat, you'll find the links to press releases and bios of the panelists today. I really thank you all and appreciate all of your help. And again, thank you so much to the exonerees who first were on this panel and shared their stories, which are very difficult, and also to the folks who signed this letter, because even putting your name on something like this, I know can be very, very challenging. So I want to thank all of you on this panel and also the folks who signed the letter. Thank you, everyone, so much.